be offered to the limited wiggle room of a court of law, of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Mazen Nandekan is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empowered the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the proceedings today.
The procedure today?
The proceedings today.
Okay.
What next?
I will yield to one of my colleagues to discuss that. By Samaswell Opera with here.
Okay, actually, it's good for us to put the record straight. Mazen Nandekan is not saying that he will not enter the fence. Mazen Nandekan said, under what law are you charging him? Going by the Constitution, there is absolutely no charge against him. That tell me the law, that the court should tell me the law upon which he's being tried. Now, my lord is also saying that whatever thing that you have to say should be include at the final written address, and it should be upon a conviction to know whether you're supposed to be convicted or not. I'm not saying that said no. There are thresholds, there are hurdles upon which you need to cross for you to reach at that particular issue. And one fundamental issue there is that my law said we are talking about issue of extraordinary rendition, the way we are being brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion Mazen Nandekan filed, Mazen Nandekan said Federal High Court has given a judgment in respect of that, and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave a ruling on that and made comment about that. The CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised, and Mazen Nandekan made reference of the motion in the court file. And under the Evidence Act, Mazen Nandekan is saying that under the law, court is obliged, is under obligation to take judicial notice of every document in their file. Yes. So asking him now to go and enter into a defense and start giving evidence on that is a waste of time. Yes. That court is on its own supposed to take so much to raise this issue. Yeah. Court is expected to raise this issue. Now there is a charge before me. Please.